Hello. Thanks for joining us today. My name is Kathy Huang. I'm an academic fellow at the Rock Center for Corporate Governance, which is a joint initiative between Stanford Law School and Stanford Graduate School of Business. So today we're excited to co-sponsor this event with the Stanford program in Law Science and Technology, and this event is going to be on IP issues in the startup context. This is the second event in our startup governance series, and it's going to be part of our regular Monday evening series. Our next Monday evening event will be on May 12th, and will feature Judge Jed Rakoff of the Southern District of New York. The discussion will be entitled, "Why Have No High-Level Executives Been Prosecuted in Connection with the Financial Crisis?" So if you're interested in that event, we encourage you to find out more about that and other events on our website at rockcenter.stanford.edu. So for today's panel, we've assembled a panel of experts to help us understand IP issues in the startup context. On my right here, we have Professor Mark Lemley, who is the William H. Newcomb Professor of Law here at Stanford and is the leading scholar on IP issues. We have David Anderson, who is the Vice President of Corporate Development at RPX Corporation, which defends corporations from non-practicing entities. And we have Neil Chatterjee, a partner at Oric and the chair of Oric's IP practice. And tonight's panel will be moderated by Evan Epstein, who's the executive director of the Rock Center. Evan?
Thank you, Kathy. Well, welcome everybody. We're very excited to have this panel today. We usually have programs in the Rock Center that are targeted for public directors and a lot of governance, and we've started recently to do more governance in the early stage. And this one is focused on IP challenges, and we're very happy to have this distinguished panel today and having this discussion. I think the idea is to have a very open discussion, so if you have questions, please jump ahead and let us know. And so I'm going to start with having the first question. If you're a founder and you are thinking about doing a startup, what happens with the IP? Let's think about the origins. What should you have as an IP? Why? And then let's move on from the early stage all the way until we go upstream. So maybe, Mark, you can start it up that way.
Right. Well, so let me start at kind of point zero, right, which is before you start thinking about your company and your IP, you came from somewhere. And anybody you hire came from somewhere. And so I think step number one is to make sure you start clean. One of the things that can really most easily bring down a young company is that the company turns out to be founded in part on a basis of someone else's trade secrets or someone else's information. And that's way too easy to do. It's way too easy to do because human nature doesn't neatly divide itself into, well, I'm working for this company and I have no thoughts about anything outside it, and then I leave, and the next day I can now start thinking about what I might do next. That's just not the way we work. Right? But it is the way trade secret law works to a large extent. And so if you find yourself in a circumstance where you're taking a paycheck from company A while making plans and working on technology for new startup B, you found yourself in a vulnerable situation, right? And especially if that new startup is likely to compete with the old one, you've got a problem. If you find that documents, computer files, anything of that sort is traveling along with you when you leave, whether or not you wrote it, whether or not you poured your heart and soul into it, and whether or not the company you are leaving has unfairly neglected it or decided not to pursue it, you're setting yourself up for a rather nasty situation. So I think there are ways you can try to minimize these risks. You need to sort of minimize these risks yourself as a startup founder. My view is, while you probably don't actually have to walk into the new job naked, from an electronic
They'd fire you if you did.
Yeah, well, from an electronic perspective, you should absolutely walk in naked, right? I mean, so the absolute safest thing you could do to protect against trade secrets moving from the old employer to the new one and creating a problem for the new company is to have no devices and no accounts in common between the old and the new. Right? Don't have an email account in which you have stuff from the old, don't have a phone or a laptop or a tablet come with you to the new one. And in so doing, you're going to minimize the risk that you're intentionally or inadvertently bringing a bunch of documents from your old employer to the new one. Okay. Neil, you want to?
Yeah, so there are a couple different, to add to what Mark said, there are a couple different components here. I always talk about it as starting up is hard to do. When you're working at a company, not only do you have trade secret obligations, most people think that's arises kind of out of your non-disclosure obligations, your employment agreements. There are also, these things are written often in a way that are horrifically broad for anyone that wants to think great thoughts that might be a little different than the job that they have. In many cases, these employment agreements will say things like, we own any idea you have, and you have an obligation to offer it to us first before you go and do it on your own. And that kind of goes beyond trade secrets. That's just a contractual right that some people may try and assert. Now, many companies believe in creating an ecosystem of innovation that they don't have to pay for. So they actually like employees leaving and going and bearing the risk of starting new companies because they don't want you to leave with a bad relationship with them, because if you actually create something of value, they may want to later acquire it. And they also don't want to create an environment where people are afraid to go out and innovate on their own, because it also hurts them on their ability to hire people into their company. You have to know what type of company you're working for. When you have an existing idea where you want to start some innovation and maybe start a new project, but you can't necessarily afford to leave the company because you need an income. It happens all the time. They get on the phone with outside lawyers like me, and people say, well, solution simple, quit your job. Quit your job and start the idea afterwards. And they're like, well, how am I going to pay rent? It's just not a practical solution from my perspective. So the key is to understand the nature of the company you're working for, how they assert proprietary interests. And in many cases, getting somebody involved early to help advise you on how and what should you disclose about trying to pursue this and when. I had a case where there was a company that was more or less failing. And the engineering department was kind of getting bored of pursuing this idea that wasn't going anywhere. So they came up with this brilliant idea to start spending all their time on the next company that they wanted to be part of. The problem was they were doing it on their prior employer's computers, on their time, being paid by that prior employer. And when they left, they all left together to start the new company. When this failing company that had made a substantial investment in the company that had lost kind of looked at that, they said, well, we're not going to get any value from what we've invested here, so we're going to sue those guys at the new company that seem to have something interesting. Maybe we'll get a piece of it. And that's not an uncommon Silicon Valley script. So that kind of leads me to my second point. You tend to want to start companies with people that you're familiar with. It's not like assembling the new boy band with a whole bunch of people who are totally unfamiliar with each other. And often all of you are working together. So when you're dealing with that, you have to, number one, make sure that you're addressing any concerns that you might forecast that an employer may have, and whether they believe in creating a new ecosystem that they want to align themselves with or not. And in between this group of friends that always starts in trust, how do you make sure everyone is dedicating whatever their contributions are to the common good, that being through a company or something else? We've all heard the stories about people in a dorm room starting a company and not having any kind of agreements. It's natural to think students in college or people that are out of work coming up with these ideas not going through some of the formalities, but at least some of them matter as far as making sure everyone has kind of said, okay, this is dedicated to a common company, and this is how we're going to break up responsibilities or ownership rights of this company. Because invariably when you have 4 or 5 people that are coming together to found something, there's probably going to be some splintering fairly quickly, just because people will decide that they want a higher paying job, or there's another opportunity that's interesting. And unpacking that after the fact is always a much more costly enterprise than doing it on the front end.
How early, in your experience, should you do that?
I like to see people forming a corporation and dedicating their IP assets very early on. Very early on. It's not a terribly expensive thing to do just that first piece where everyone's getting kind of their stock ownership and stuff like that in exchange for dedicating it. But I like doing that early on. Let me just add one other thing. A lot of people think that all of their relationships with their employer is driven by their employment agreement. If you're a senior executive, and sometimes even when you're a kind of a mid-level executive, you have something called a fiduciary duty or a duty of loyalty. And that is a broader set of responsibilities you have to your company beyond just what the employment agreement says. And it's the same concept that if you have a nifty idea that's within the scope of the business that you're working in, and that's generally thought of as pretty broad, you have to offer it to them first. And once they reject it, you can then pursue it on your own.
So let me just, because all of this sounds pretty dismal if you're about to start a company, let me just note a couple of things. We're actually in California quite a bit more liberal than pretty much anywhere else in the country. So some things that your former employer cannot do, they can't prevent you from competing with them at all. Even for a limited period of time. Non-compete agreements are void in this state unless you were in fact the owner of the original company and you sold it. And so I've actually been quite surprised how many companies employing people in the Valley have them sign non-compete agreements anyway. Those are void. Those are of no effect. Yeah. The only thing they exist to is to try to scare you. So that's good news. They can't prevent you from starting a company, right? They can't prevent you from taking your idea, even if you developed it while you were at the company, if you developed it on your own time and if it is not directly related to the work you were doing. So if you're not going into competition with your former employer, you're going off in a different direction and you're careful not to use the employer's time and resources, even if they say by contract we own everything, California law forbids it. And they can't prevent you from hiring anybody who wants to come work for you. Even if they did work with you in the past. It's true, as Neil suggests, right? The more people you kind of move en masse from a group, the more nervous the former employer becomes, and the more likely it is that you're taking some trade secrets of the former employer, and you can't do that. But there's nothing that prevents you from starting up as long as you can find ways not to take either information they've given you that's a trade secret or your own ideas that you came up with while you were working for them and that you owe to them.
Yeah, well, just a couple of things. I don't 100% agree with Mark on this because the more senior executive you are, the more obligations you have to the company through duties of loyalty and these fiduciary duties. The difficulty I have with this California statute that says if you develop stuff on your own time with your own computers, that it's yours, not the trade secrets or anything that the company can lay title to. The difficulty I have with that is not reflective of the way we work today in technology companies. We totally scramble the eggs in our daily life between personal and professional work. We all have mobile devices often that are they'll have Angry Birds and they'll have proprietary email access, and so they get more complicated. I would say that the reason that it shouldn't be as dismal is because people don't want to spend a lot of money filing lawsuits and making claims against something that is unproven in worth. There isn't a return on investment, so it's the exception, a very rare exception, that a startup gets sued for some kind of theft or some sort of claim. The issues arise if you become very successful. If you're 2 years out and you become very successful, all of a sudden you start having a target on your back. And one of the great signs of success is the fact that you're getting sued.
David, why don't you tell us your experience and maybe talk a little bit about RPX and what you do as a context?
Sure, yeah. So I'm the only non-lawyer on this panel. it's actually interesting, as I was just sitting here, so RPX went through exactly this journey. We were founded in 2008 with Kleiner and Charles River Venture funding. We IPO'd in 2012. What's probably, and just so everyone here has context, because most people haven't heard of RPX, what we do is we help companies manage their patent risk. Primarily what we do is we buy patents before they get in the hands of non-practicing entities or NPEs or patent trolls. We also resolve suits that are held by our clients. For most of our clients, about 1 out of 5 of their dismissals comes through RPX now as opposed to their outside counsel. And then we also offer insurance. So if you're a startup, we insure companies for NPE and other patent-related risk. I guess the only thing I'd add to this discussion of the early stages is, as less a legal perspective, but I was actually talking to our founders about their early days and when they founded the company, and obviously we had 3 founders, 2 of which were lawyers, and 1 of which was a bond trader, and we were in the legal space. But in terms of priorities for those early board meetings, I mean, there's a very small amount which is spent dedicated to these sorts of issues. I mean, primarily we're talking about recruitment strategy, funding strategy, sales strategy, these sorts of things. So it was, I guess the only thing I could add maybe to the beginning of the evolution is, relative priorities in terms of where as a good director one might want to spend their time.
Okay. The higher the dollar value of the Series A investment, the more the questions of, is all the IP in the company arise? So there's actually a fairly direct relationship on those questions, but certainly there are other questions that are very important that are asked.
Okay. Mark, maybe now we should move into, we founded a company, now we have some IP. What is the strategy with the IP? And how should the board or the founders, which are the same often in that stage, how should you think about your IP strategy?
Right. Yeah, I mean, I think the first thing to ask is, do I have an IP strategy, right? It's certainly, especially if you're a board member, does my company have an IP strategy? And if so, what is it? I'm amazed actually at how often sort of people don't think about the question of what do I want, right? Why am I participating in intellectual property, right? So you are, if you have an idea and you start developing some technology, the short answer is you probably have IP whether you want it or not. You likely have trade secrets as a matter of course because you've kept some information from the world. You almost certainly have copyrights, especially if you're a software company. It's hard to avoid creating intellectual property almost by accident. Now, other kinds of intellectual property, notably patents, require a substantially greater investment. You got to put in a bunch of money, and you got to wait a bunch of years. And then there's trademark law. There's your brand, which everybody is going to create, and you're going to want some protection for the name of the company, the name of the product you're going to sell, and so forth. What you ought to be thinking about, what you ought to be doing, and how early you ought to be doing it, I think is a function of what you hope intellectual property will do for you. And that really, I think, differs dramatically by the industry you're in, by the kind of technology you're developing, and so forth, right? And so, on the one hand, on the one extreme, I might start with a biotechnology or a pharmaceutical company where absolutely critical to the success of the company is going to be nailing down and protecting patent rights in the things that we're inventing, and part of the play, whether it's sell out to a more established pharmaceutical company or run all the way through to FDA approval 10 years from now, is all going to depend on, do I get intellectual property protection? Move that to the other extreme, if I'm in the software world and I'm operating in the open source environment, right? It's the kind of assumption is, well, I don't need IP, I don't need to worry about IP, I'm just sort of staying out of that world. That's not exactly right. It turns out that the open source agreements are based on copyright. You need to think about sort of what I'm releasing and under what circumstances, what I'm bringing into the company from other open source folks and under what circumstances. But the way in which you think about it, I think, becomes completely different. Right? So if I want intellectual property rights in order to keep people out of my market, to keep them from competing with me, to force them out, right? Then probably what I want is a patent. I want to be applying for that as early as possible, and I got to understand that it's going to take a long time. That my market play is to get a patent right and to enforce it is a 5, 6, 8, 10-year market play. If what I want is to be left alone, to do what I want without being subject to interference by others, I might still want to get patents. In that case, we're going to care a little bit about the industry, who the other folks are, what their intellectual property portfolio is. But I might want patents here primarily to defend myself against other people who have patents, right? To protect my investment by creating rights that I can then trade away, right? Trading cards to allow myself a freedom to operate. But again, understand that a patent takes 4 years on average to get through the PTO. This is a long-term play. If what I want is to hit the market like a ton of bricks 12 weeks from now with an app I've just launched that's going to take the world by storm and make a lot of sales really quickly, patents don't sound like such a great option anymore. Right? Now what I got to think about is how do I maintain secrecy of what I'm doing until I'm ready to launch? What can I get out of copyright law to prevent other people from counterfeiting my app, from making piracy decisions and so forth? So I think whether or not you're kind of planning to hire an IP lawyer early on or investing in patents really does depend on what's my business model and what's the role of IP in that business model.
So I'm glad you brought up the point about patenting. So our company is in any given quarter the first or second largest buyer of patents in the world, and yet I'm astonished how eager startups that we see are to patent things. It's usually they don't know why exactly, except they thought it was a good idea and their VC told them to do it, probably because of the liquidation value, which is sort of a funny thing for a founder to care about. But the other reason if they give you one is because, well, what if I've got competitors or larger companies that sue me? I need something to fight back with. To which it's really bizarre. You wonder what the business case is for that. Firstly, if you're looking to hit back against someone, what you really want is a patent on what they do. And you want a patent on what they do that earns them a lot of money. In which case, wouldn't you be better off waiting for that suit to occur and then go out and buy a patent that does that for you, rather than try to bet 3 to 5 years, if not 8 to 10 years in advance, what patent you're going to need in that particular situation? And so, I have to imagine that if you said to the whoever's proposing, let's go ahead and patent, and I think the caveat you gave was a good one, like let's not talk about pharma or life sciences here, but in sort of general information technology, that'd be really hard to make that business case. To say that, what's the chance the patent gets approved, times what's the chance I need it, times what's the chance that it's going to be the right patent for the situation in which I need it, times the chance I'm successful, discount all of, times the change in economic outcome I'm likely to have, discounted at, a startup discount rate back anywhere from 3 to 5 to 10 years, and you're going to say, yeah, that was really worth it to patent now, instead of going out and buying a patent when I needed it. It's sort of an observation that I guess we've had over the last few years, is that there seems to be a lot of interest in patenting, primarily for this idea it's going to be defensive against other companies, yet I often struggle to make the business case in my head, even with fairly stretched assumptions as to why that makes a lot of sense.
Yeah, I guess my take on it is a little more ruthless, which is the way I think companies that are starting up should think about IP is whatever the VCs that are funding you tell you it should be.
So I think Neil's exactly right, but it runs into David's problem, right? So that is the number of companies who get patents reflexively because they're to impress their VCs, right? Because the VCs want patents, I think is considerable. The question is, then, well, why does the VC want you to have patents, right? And invariably, the VCs do not want you to be involved in litigation, right? The very last thing they want is for their startups to be involved in litigation.
Right, but I've seen, at least with the startup companies that I work with and the funding events that are occurring, a significant change in the Valley over the past 6 or 7 years for startups. And it isn't a universal change, but it certainly is a change in the level of activity. 7, 8 years ago, if you were to tell the VCs generally, not everyone, but generally, we're going to spend umpteen thousands of dollars filing for patents to protect the core assets of our company. the VCs generally are going to respond, you're out of your mind. Go hire another engineer. This is a racehorse, and you got to get the product out the door. You've got to get the users engaged. If it's an infotech company, you've got to get customers lined up and execute on a sales strategy. We don't want to have you distracted by talking to lawyers and spending all this money to get an asset that's going to take 5 years, 7 years, 10 years to get, and even then it's uncertain. In today's world, there's a much higher percentage of people that are saying, okay, if this company tanks, I will still have an asset, that being a patent or a patent application. And that asset has value that can be sold for some amount of currency to someone like RPX. So if my company tanks, I at least have some piece of value that exists independently of the business that I can still try and get some level of an ROI. So I'm going to use this patenting strategy as an opportunity to manage some level of risk on the investment that I'm taking. And not every VC, in fact, I'd say most VCs don't necessarily think that way, but there are a lot more that do today than have before. And I think the reason for it is really two reasons. One is they're looking at these massive transactions going on between very, very large public companies that are buying and selling patent portfolios for hundreds of millions, if not billions of dollars. And they're saying if those portfolios of patents can have huge amounts of money, giving value to it, even though this is a smaller company, they'll probably be able to get some patents that'll create some revenue if the company doesn't pan out. And they're, while they will often kind of give the speech of NPEs being a tax on startup companies, which they are. They also are not going to be shy about selling the patents should the company tank, and they think they can recover some asset value. So that's the first reason. The second reason is that bald guy on Shark Tank, where every time someone comes in to sell whatever crappy new business idea they have, hopefully none of you were on Shark Tank, and his first question is what do you have that's proprietary? And as much as I kind of jokingly say that, it does affect people's mindset. It starts a dialogue about what is the core asset value of the company.
Well, so let me just follow up on that, because I actually think the underlying question, what do you have that's proprietary, right, is actually a really valuable question. And one of the reasons VCs care about patenting is not because they think they're going to get you're going to win a patent lawsuit, right? Right. It's a way of asking the question, how is it that I distinguish myself from my competition, right? What is it that I've done that I think is actually, right, technologically an advance over the world, or an advance in the business model over the world, right? And that's a useful question to be asking, whether or not you wrap it in a patent application and send it off to the PTO, right? VCs and startups and board members all ought to be asking that question. I do think there's a disagreement in the venture community as to whether the salvage value is worth pursuing, and part of it may reflect the increasing conservatism of at least the sort of more traditional venture capital model, right? No self-respecting venture capitalist circa 1990 would care at all about salvage value. Right, we're aiming for the success, and if it fails, we just walk away. But I think as venture capital firms have become more and more like banking firms, and the real venture work has been done by angels and other kind of early seed stage stuff, we've seen more and more venture capitalists who are thinking about this as kind of life cycle management and asset pricing. I think
you're right that. Just like there's some irrational exuberance about the value of patents generally, probably that's caught on with some VCs who think, these things could be worth $2 to $3 million for each patent. And I'll just say is, our company looks at 80 portfolios a month. We probably buy 1 or 2 of them every month, and our price, per patent or per portfolio has not changed in 6 years. And you're talking, generally, on average, you're looking very, very low, 6 figures, sometimes 8 figures on the values for these patents, and most of them are not transacting. So, my bet would be, in general, it's wrong to think there's some meaningful liquidation value, and probably the distraction cost of filing for the patents and getting your engineers offline to work on this sort of thing. The difference in the expected value of that entrepreneurial venture that came from that, was way bigger than the difference you might have got in the liquidation value in that scenario.
Yeah, so I tend to think of these things, just to add to this, and it relates to Mark's initial comments, as 4 questions that kind of frame the issue on how you protect, how you should think about IP. The first question is what is my value proposition? The CEO of McDonald's, like 20 or 30 years ago, was asked, what is the value proposition of McDonald's? And he said, well, it's not the secret sauce. He said, fundamentally, the value proposition of our company is we're a real estate company, is we know where to put a place where people want to buy hamburgers. But it isn't necessarily the hamburgers, it's the fact that we're a real estate company because we have all of this property that we own that is in heavily trafficked areas. And understanding the value proposition that you're trying to offer to the market is really the starting point on defining an IP strategy, whether it's protecting data, trade secrets, trademark rights, copyright rights, or patent rights. The second, what are the threats to my value proposition? Because again, that's going to start answering the question about how do you protect this and what's the right kind of legal structure to do that. The third is related to that, is how do I protect against my threats? So what are my threats, and then how do I protect against the threats? It could be that your biggest threat is a large company with a huge patent portfolio coming and seeking a license. Most of the time when people talk about a defensive portfolio, patent portfolio as a startup, they're more worried about something that could be out there, not something that's actual and known. As a startup with limited funds and resources, it's very important to focus on things that are actual and known. And the final thing is it worth it? The time value of what you're going to be doing, the amount of investment effort that it's going to take in terms of the opportunity cost of taking engineers or business people out of their role and putting them into a protection of IP structure gets more and more complicated the more you decide to invest in that. Now, I think that you're always going to want to do certain things to protect your company depending on the business model. But I do think people are sometimes over-exuberant and they forget to ask the is it worth it question. So what is your value proposition? What are your known threats? How do you protect against those known threats? And then is the effort to protect it worth the return on the investment?
Great. So now imagine the company's already, it's got some venture money in it and is thinking about an exit liquidity. What are the issues that come up in IP that you see in IPOs or more importantly in M&As that you think you see in your practice, for example? Mark, maybe you can start.
Well, I mean, I think one question is, right, what's your exit strategy, right? So if my exit strategy is IPO, I think the answer is I'm operating the company, I'm going to continue to operate the company, albeit with more cash, right? And so presumably I've already made the earlier stage decision we've talked about, right? What am I going to use this IP for? It is the case as your company gets more mature, right, that you're looking around and seeing upstart competitors who want to steal some of what's made you successful. And so you got to think about that. If your exit strategy is acquisition, and then the first thing I think you want to know goes back to sort of Neil's original first question, right, which is now I care not about the attitude of my former employer, I care about the attitude of my potential acquirer. Right, and so different acquirers have very different approaches to intellectual property, and that's going to be reflected, I think, in what I need to do. You absolutely need to make sure that whatever rights you've got, that your house is in order. So one of the things that's going to happen in the mergers and acquisitions process is a period of IP due diligence, along with the overall due diligence of the company, in which IP lawyers will be paid to come in and make sure that all your employees have signed contracts that assign the inventions to the company and that they haven't actually stolen trade secrets from other people and that the underlying code in your software is not in fact based on stuff you took from open source platforms while intending to have it remain proprietary, and that you've actually sort of filed whatever patent applications you're going to file and you've prosecuted them appropriately. They're also going to do due diligence on the sort of negative side, on the defensive side of it. I think we'll talk about that in a minute. So, I mean, I think as you're sort of positioning yourself for this exit strategy, this is if you've gotten to this point and you are successful, right? You're hopefully reevaluating the question of, well, all right, are patents now seeming like a better option, even if they weren't early, because I'm getting larger and I'm more of a target for competitors, that you're maybe thinking about filing. You're filing patent applications. You're building your intellectual property portfolio if you think it's appropriate. But I think here the key is going to be making sure that your house is in order, that the kind of chaos of the early days is brought into some kind of order before it's all just handed to the acquiring firm, because the acquiring firm is going to pay a bunch of people who will try to pick it all apart, and their natural tendency, A, because they're lawyers, and B, because they're hired to do this, is to find problems, right? Not to say, oh, don't worry, everything's fine.
Yeah, I think it's nice that we're kind of doing the life cycle issue here, because either a liquidity event or an acquisition, you do go back, at least at the starting point. I think those points that Mark raised are right. The starting point is what have you done to protect your core value proposition? And did you actually live up to protecting whatever your core value proposition is? And if it's patents, have you done all the procedural formalities that are required? People are always going to want to make sure that everyone that's come into the company have signed agreements to dedicate their IP to the company, that the founders did that too, and there weren't kind of extraneous facts where someone else could lay title to it. And if there is that issue, there might be issues that arise about decreases in the valuation or holding back a reserve in case someone might sue you, various things like that.
You've never had any experience with a case like that?
Never, ever. But those are the exception, not the rule. In most instances, they're going to say, "What is your core value proposition? What have you done to protect it?" And then show me what you actually did, so I can make sure there aren't warts around it.
I guess I would just add that, to say it kind of bluntly, if you've been reasonably successful, as has been said a few times before, you should just expect to be sued, at least in the patent space. I think it's 40 or 50% of companies that have more than $50 million in funding receive some sort of NPE lawsuit after the point at which they receive $50 million in venture funding. The majority of defendants in NPE cases are actually private companies. They're also companies with less than $100 million of revenue. But that's sort of just bad news, so what could you do about it? I guess there's two things one could point out. So one is on the NPE side, the majority of all those patents that are being asserted against companies on the NPE side are acquired in the open market. It's other failed companies that have, there's a liquidation, they sold off the patents, or it's operating companies selling off the patents. And if you can just keep an eye on that market and see what's transacting there's often opportunities to buy those patents before they get asserted at a fraction of the price and certainly a fraction of the headache that you would have if they were asserted. The other is from the competitive side. This is probably a reasonable time to start making a map of where you have those risks. So what companies own patents that might be a risk for you, which ones might have an interest in suing you, and this is a great time to go out and try to acquire patents that you might be able to use in a countersuit. You really don't want to get in a patent lawsuit anytime before you IPO, I would imagine. And I've never heard a company say, "I'm really glad we launched one proactively." It's a lot easier to go acquire something in the open market that reads on Cisco's routers than it is to go patent something yourself, wait 6 years, and then hope that it's still useful for you if Cisco's knocking on your door. Certainly by this time, IBM's knocking on your door, and a bunch of other licensing entities. So it's just something I think one should expect and be prepared to deal with at that stage in the development.
So let's talk a little bit about that. How has it evolved, the patent litigation? Obviously, it's huge today. Maybe, Mark, you can talk. Now you're a public company. Now let's talk about NPEs and the reality in which you have to deal with your IP as a public company. And how's it evolved in the last five years?
Well, so first off, as David suggests, right, you don't have to wait till you got a public company before you're worrying about this, right? So all you have to do is have some revenue or increasingly some pretty good prospect of revenue, right? Venture funding will do, and you will attract suits by patent trolls. But beyond that, it turns out that the more money you make, the more people sue you. Now, this too is an industry-specific question, right? We don't see patent trolls primarily in the biotechnology space or medical devices. There are a bunch of different reasons for that, related to the nature of the patents, related to the nature of the technology, and the speed with which the technology moves. But in the software and the information technology spaces, a sort of constellation of different issues has made this a really dramatic development, I think really just in the last 10 or 15 years. And part of it is product life cycles move very quickly in software and internet work, but the patent office doesn't move that quickly. And that means that every patent issued in the software world, by the time it is issued, is obsolete. Right? And so the people who are asserting it are either asserting it against old technology, looking for revenue from past technology, maybe, or what they're doing is they're taking a patent and they're asserting it against a new generation of technology that looks pretty different. And that in turn relates to a second problem, which is it's really hard to tell in the software world exactly what a patent covers. We have a good language in chemistry and biotechnology for figuring out what's inside a genus of chemistry, right? Whether or not I have this DNA sequence in my thing. We don't have that good language, at least in patent law, for software. And the third problem is we've got an enormous number of software and IT patents because we've got really complex technologies. David Drummond, the chief legal officer at Google, estimated a couple years ago that there were 250,000 patents that could read on a smartphone loaded up with apps. They were issuing about 50 or 60,000 smartphone-related patents a year, so that number is probably closer to 350,000 right now. And so that, I think, creates a more fundamental problem, and I think I probably disagree a little bit with David as to kind of how well you can manage that problem by finding the key patents and buying them. I think there are so many and they are so vague that while you can get rid of risks you know about, you're never going to get rid of the risks you don't know about. And no matter how careful you are to read the patents and say, I'm going to buy up the ones that really read on what I'm doing, somebody will guaranteed come out of the woodwork with a patent that you might look at and say, that's got nothing to do with what I'm doing. But the answer is until a court rules on it, it's really hard to tell. So the sort of practical effect of this has been thousands of lawsuits a year. In the IT industry, something like 80% of all patent lawsuits are filed by patent trolls or non-practicing entities, not by your competitors. And it's become a fact of life. And what can you do about it? You know, people have tried different strategies. So one strategy is the RPX strategy, right? To try to insure against it, to mitigate the risk, and kind of equalize the cost a bit in a sense, right? Mitigate the uncertainty of outcome. There's a strategy that says, I'm not paying these people a dime no matter what, and I'm going to get a reputation for fighting them. Newegg has tried that, I think, probably with some success, although I'd like to see some empirical evidence on that. And, you know, the other strategy is to say this is a cost of doing business and a cost of success. And I pay a bunch of people to go away, even when I think they probably shouldn't be allowed to sue me, because that's cheaper and less disruptive to my company than sending my engineers and my business people to trial in hopes of invalidating this patent when I know there's another one down the line after it.
Neil, maybe you can...
Yeah, I mean, I don't have a whole lot to add beyond that. NPEs are changing in the world today. There's the extremely well-financed patent troll, and the guy in Kentucky that just bought a patent because he heard he could sue people on them and he wants to buy a new horse for his ranch. And you literally have an entire continuum of people who buy patents and who then assert them. And you know, when you get over a certain, by the way, I'll give a plug for NPR. NPR did a great program called When Patents Attack. They had a When Patents Attack Section 1, and then they had a follow-up one. It was a really terrific program, and I'm not just saying that because I talked about a couple of cases that we were deeply involved in, but it was actually it was really well done in talking about the problem of patent trolls in a very layperson voice, so you can understand the business issues and why we need companies like RPX out there. But it is a cost of doing business right now to deal with patent trolls, both big and small. There are a lot of initiatives afoot, some of them private, like RPX and other entities, as well as public ones, or you hear about patent reform. Sometimes they're successful, sometimes they're not. But some of the new patent reforms have done things to reduce the transaction costs for companies. So litigation is outrageously expensive, and they're trying to figure out alternate avenues to deal with some of the problems in patent litigation that are cheaper, to change the economic calculus for patent trolls when they're filing a patent claim, because it's going to be harder for them to get money back, and it's going to increase their operating costs while decreasing the operating costs of the defense. For startups, even though I know we were talking about public companies, there is a fairly common dialogue that happens where when you're a startup, you're hit by a patent troll. There's and sometimes it might even be some other kind of IP case, like a trade secret case. There's this initial, very visceral response. The boards will come in and they will say, we have to fight this on principle. We have to fight it on policy, because this will not be the last one we have, because we're already on the path to being extremely successful. What happens is they forget about that statement they made when they committed to fight to the bitter end 9 months down the road, or 12 months down the road, when they've spent countless hundreds of thousands of dollars defending themselves. The courts have done nothing, and there's nothing to show that the case has moved forward towards final resolution, but they know they've spent hundreds of thousands of dollars, if not millions, that their engineers have spent time in deposition rooms, and now they're looking at having to do another funding event and having dealt with it at a board level month on month. So what I typically do with startups is I say, I understand the concept of fighting on principle. That's for the multi-billion-dollar client that gets hit with 50 of these, that needs to fight on principle. Right now, we need to think about it in a business decision, because I can guarantee you 9 to 12 months from now, you're not going to be feeling the way that you're feeling now on fighting it on principle. You're going to have buyer's remorse. So if you guys want to fight it, that's fine, and I'm happy to do it. But I want you to know that it's better for you to be investing in your company, even if you feel like you're paying a little bit of grudge money to get out. Of course, if the ask is too big, then the board needs to know that too, because it's making a conscious decision to fight, not because of the principle, but because the ask is too big.
Mm-hmm. Yeah, it's funny, we've been, by the way, I love your point about the not knowing where patents are coming out of the woodwork. My favorite example of this is we had a portfolio come across a while ago that was for, I don't know how many of you remember Life Alert. It was this thing that hangs from your neck. I've fallen, I can't get up. And it was being shopped on the market under the guise that, well, it's you depress a button and it alerts the authorities. And they said, well, look, anytime you dial 911, you're pressing buttons and you're alerting the authorities on a mobile device. And of course, it's fine, except it doesn't work on touchscreen phones because you're not mechanically pressing a button. But you really just have no idea where these things are coming from. So you generally they're going to come through some market mechanism, but it's really hard to find. I will say it's interesting on the NPs. The thing that we've done a lot with clients is try to bring data to the decision-making process on whether they should fight or whether they should settle, or if they should find some other ways to resolve the matter. It's really astonishing. Sometimes, particularly for the first few suits companies see, they really hire some expensive lawyers to deal with something that they might be able to get out of for $25,000 or $50,000, either because they feel it, really viscerally, like they want to fight this thing, although they often change their mind, half a year or a year in, or just because they don't know what else to do. And with a little bit of information and doing a little bit of research to get a sense of, is this a really serious matter that's core to what the business does, or is this something that's really kind of a nuisance and you're just going to have to decide if you want to fight all of these things to the death, or if you're just going to make kind of a prudent NPV analysis and decide that this is the one that we want to get rid of. And it's sort of hard to do that unless you have some reasonable data about what's going on in these campaigns, what we think of the patent, and bring that to bear on the decision.
Great. So we got about 10 minutes, so we'll open up to the floor and questions, and we'll hope to answer as many as we can.
You mentioned at the beginning that you cannot enforce non-compete. That's not the case for advisory contract or consulting contract. Can you specify? A lot of the company are trying to hire people in the early days for consulting contracts.
Oh, so do you mean consulting contracts where during the term of consulting, you're not allowed to work for someone else?
That's right, but also afterwards that you cannot hire people away from the company, or that you have an assignment of IP that can be enforced?
So there's a couple points to that. One is whether you can go and work for a competitor after you're done with your consulting gig. Those are unenforceable under California law. Whether you can hire people away from a company, those are called non-solicitation agreements. And the law for that is, I don't know, I would characterize it as in a state of flux.
Murky. So here's the kind of best, the law in California is definitely murky, right? So there's a one line of cases that says, well, we'll draw a compromise that says you can't go out and affirmatively solicit everyone to come work for you, but you're welcome to hire anyone who comes to you. You can tell them where you're going, and if they come to you, that's fine. And for a while, at least, that was the California law, and it probably still is the California law, but there are some cases that suggest that maybe there are more limitations on your ability to hire those people.
And another quick question. I'm in the middle of an M&A deals. One of the big problems with the IP is, the escrow as well as the clawback for the IP reps. What is exactly the standards out there? Because, some people just say, hey, they have the right to basically get all the money back if there's no freedom to operate or something like that. And what's the time limitation? What's the standard in the industry?
I'm not sure I've seen a standard in the industry. It depends on the scope of the deal and the nature of the deal. I have not seen, every single one of those provisions that I've been pulled into, and I don't get pulled into a ton of them, but I get pulled into, I would say a half dozen a year. I think every single one of them have been negotiated when someone's real concerned about that stuff. Typically, that's being done with a known risk. And typically, that gets resolved by having a holdback escrow for some period of time where there's going to be something to fund or settle litigation. And they try and quantify it in some way. But not always.
Yeah, but I think Neil's right. It's almost always where we think there's a particular risk, right? So Google buys YouTube and they say we're holding back X amount of money because Viacom has sued these people and there's some possibility that we'll have to pay out a lot of money. Yeah. If the idea that someone was trying to push in this agreement was, well, if you get sued for patent infringement in the smartphone or the software space, then the deal's off. No deal would ever get done in Silicon Valley because as we said, you're going to get sued by someone for something in the IP space, and it can't simply be that, right? So, if the holdback is, if there's any litigation whatsoever, we'll take it back. I think you just got to treat that as not a part of the asset price, right? Then the answer is it's illusory and doesn't exist. But if it's for a specific piece of information, or specific litigation, or a specific plaintiff who might sue you, then I think it's it's going to be a case by case.
That issue does get a lot more complicated when it's purely an asset acquisition and the company selling the asset is going to continue to exist as a viable entity. It gets a lot more complicated.
So I have two questions. First, thanks for the talk. One was regarding the patent term, the pendency of the patent filing to the grant. So the USPTO has a Track 1 filing now. So there are a number of companies that will get a granted patent in 3 to 7 months that I'm seeing. And so I'm curious about how that changes your calculus, because you've mentioned that as an important consideration. And secondly, I wanted to ask you about the provision about companies or venture funds in the 90s and now that feel that they're going for the big hit, letting the patents just go by the wayside. And that seems to me to be a illogical strategy because of the fact that an inventor retains the right to file continuations in part. So if the patent application were published and that company later was dissolved in some way, there's a risk that the inventor could potentially file a continuation in part and own that patent application's child application separate of the company.
So let me take them in reverse order. I think on the contract question, on the continuation in part question, if you've drafted your company's invention assignment agreement correctly, the employee's not going to be able to take that with them when they go, right? That is anything that's sort of built out of or kind of follows on from the chain from this initial application is going to end up belonging to the company or to whoever buys it.
There are some scenarios when that can actually not necessarily be the case. For example, the case where Neil described, where the company's assets were certainly sold to another party, and the patent applications that remained in that parent company were abandoned prior to that acquisition by the other party. So the company that acquired the assets of the company couldn't buy the patents that were already abandoned. And then there's a risk where the inventor will file continuations in part, which don't necessarily depend on just that chain, but predate the applications.
Well, I mean, so we're into now a very specific set of circumstances. Although my general sense is that you can control that by an invention assignment contract. By just saying, you know what, anything that comes out of this chain, whether it's a CIP or not, is going to belong to somebody. Maybe that people don't, right? And it may be that in that circumstance there's something going on there.
Yeah, I would say that the inventor was an idiot and he should have filed a brand new patent application. If you came up with something new. I mean, why put yourself at risk to say that the previous company, however failed it may be, has an ownership interest?
Yeah. So let me go back to the first question, though, because I think this actually is valuable. The Patent Office, just in the last few years, has adopted a pilot program called Track 1, in which I pay extra money and do some other things up front to get my house in order, and in exchange I get expedited examination from the PTO. I actually think this has been successful in the circumstances in which it's been used. It hasn't been used all that often, but it seems to me actually a really valuable thing for mission-critical IP in a fast-moving industry. Right, so it seems to me the two circumstances in which I want to use it are, right, I know that this patent is actually really critical to my company. It's not sort of a might be nice to have. It's not a kind of, could be good in the future, but it's critical to me. And maybe one of the reasons it's critical to me, to go back to the suggestions that my co-panelists have made, is not because it's my technology exactly, but because it reads directly on the technology of the competitor who's been making noises like they're threatening to sue me. And then I think that that time be of the essence, right? In the pharmaceutical industry, in the biotechnology industry, it's not obvious that I need a patent in 3 to 7 months, right? I'm not going to get FDA approval for 7 to 10 years. There's no reason to rush. But where I actually need a patent in a hurry, there may be reason to do it.
For our purposes here, the fast track process, right? It gives you a right that you can assert quickly. Most startup companies are basically going to pay more money to get a patent that they could assert that they're going to spend money litigating instead of building the company. For this particular group, I would generally think it's not going to make a lick of difference, because you're either spending money prosecuting getting a patent, or you're putting your patent at risk and diluting assets from building the company by hiring more engineers, more salespeople, more executives to grow asset value. It may help if you have an investor that really wants to see that you have some patents.
Right. So there's, the filing cost of that $3,000 is usually a fraction of the legal fees. With that aside, there's also a second track that the USPTO now has, which doesn't require the applicant to do any diligence. They file it directly and without doing that extra work of a search report. So I don't know. It's an interesting thing.
That's an interesting question.
Hi, thanks. My name's Todd Elmer. I'm the Chief Communications Officer at the USPTO, so I appreciate the opportunity to be here. And this has been fascinating. Happen to be in the area for some meetings tomorrow, so this was serendipitous. I've enjoyed being here. But a couple things I wanted to elaborate on. The Track 1, absolutely, I'm glad y'all brought that up and talked about that. That actually program is much more accessible than what most people realize. It's $4,000 is what the cost is. Additional cost is, and that's not including your lawyer's cost, but just the cost that's paid to the office. And small and micro entities actually have the ability to receive discounts up to 75%, so for as little as $1,000. So I wanted to add that on there. And then a couple quick things. There's been a lot of talk about patent trolls, obviously, for a lot of reasons. The Obama administration is really focused on this as well, as is the PTO. The Obama administration has come out with about 7 executive actions some of which deal with how the PTO operates, how we can operate better. One way that's actually quite relevant to startups and actually has a connection with Professor Limley, which we're pleased also, is and we have a new patent litigation toolkit that can be found on our homepage. It's designed specifically for companies, especially Main Street companies, especially startup companies that are facing potentially abusive patent litigation. And it's got a whole suite of resources, everything from, what do I do now? What does this mean? What should I do? Do I need to get legal counsel? And then there's a bunch of external resources, one of which is called Lex Machina, which is an amazing startup that has some ties to Professor Limley's work here, and which basically gives you a wealth of information on the patent that's being asserted against you. Has this patent been asserted against a suite of other people? How many times has this patent been asserted and successfully? So a lot of information that can help you decide, am I facing a patent troll, and what should I do about that? So encourage everyone to check that out, homepage of USPTO, Patent Litigation Toolkit, button right on the homepage. And thank you for having this.
Thank you.
To Neil's question 4, what does it cost? Beyond the intangible costs that you identified, what are the hard dollar carrying charge costs on a rough per patent basis that you see in the industry? Is there any empirical?
So there is data on this. I mean, I think to get a patent all in, you can probably expect about $15,000. That can jump up if it's a hard case, right? They fight you and you got to go to appeal or something of that nature. It depends a little bit on technology complexity in the industry. There are companies who've negotiated down flat fee deals where they're going to pay their lawyers, only $3,000 or $4,000 for a patent. They're going to pay another sort of $3,000 or so in fees to the PTO. But those are mostly kind of in bulk deals with large companies. Once you get the patent, you'll end up paying maintenance fees every few years. Those start out pretty low, especially if you're a small entity, though they'll get bigger over time. And then there's the cost of litigation. Right? If you get involved in a patent lawsuit, the patent lawsuit involves a substantial amount of money. It's not a kind of a small issue. It's a big one. The median cost per side in legal fees is on the order of $3 million if the case settles or is resolved by summary judgment, and $5.5 million if it goes to trial. So there's a real disconnect between the cost of getting patents and the cost of doing something in court with those patents. And the latter in particular is not for the faint of heart.
So I'll give a slightly different answer. I think Mark's right on the averages. When you're thinking about seeking patents, you have to go back to what is the value proposition I'm putting together for the patents. Because you might want to look at it philosophically as a numbers game. And if you look at it philosophically as a numbers game, you basically want to be able to deal with the defensive portfolio where they come in with their stack and you have your stack. Okay, that's great. But that's really looking at minimizing the cost on a per patent basis that it takes to get it, because you're really just comparing stack sizes, essentially. And many people do that. And having a lot of patents, they figure there's got to be something good in there because I have a lot of them. And large companies do that all the time. They kind of mine through their portfolio and they go, well, we got a lot of garbage here, but we got 2 or 3 that you can kind of twist and turn and they look like gems. The other way you do it is you say, okay, I have some core things that are important to my business that I can monitor what other people are doing to see if they're actually making use of this technology. And I'm going to invest and spend more than the average amount. And I'm really going to spend some money to make sure that I'm thoroughly protecting the core value propositions of my company. And it might be for assertion purposes, but it's also just for defensive purposes because I'm protecting the core assets of what my company's value proposition is. The problem with that second one is typically if you're at a Series A stage, your company's going to take a lot of twists and turns, and you may not necessarily know what your ultimate value proposition is going to be. But it does require a little bit of business thinking about, am I going to go for just having a sheer numbers game, or am I going to go for protecting what I think are the core assets, or am I going to try and do something in between?
The only thing I would add to that is to about the cost of the litigation. In the case of NPE suits, so when it's an NPE who's asserting, what we found is that there's, when we survey members about what it costs them to resolve those suits, firstly, in all but the most expensive cases, more than half the costs they have in resolving those suits are legal. So it's not the settlement, it's their own outside counsel. That's the majority of the cost. Also, for about half the suits, the whole thing, settlement and legal together, resolves for less than $500,000. So there's a whole bunch of really crummy suits out there where the settlements are going to be, low six figures, and you'll probably have equal number, perhaps slightly more legal fees to get there. And they're, you can argue if that's significant or not significant, but it's not. So few cases make it far in litigation that the averages end up being quite low, or at least the medians end up being quite low. And then on the patent prosecution side, our clients tell us something similar. I'm curious what your experience has been, but it's sort of $15,000 to $20,000 to get a patent, but more if you're a startup and you can't negotiate a good deal. So.
Okay, unfortunately, we've run out of time, so thank you very much for the panel, and thank you for coming.